Morning, everybody, and thank you for attending our webinar, A Guide for First-Time Lawyers, with myself, Graham Mead, and my colleague, Ellie Claffey.
Hi, good morning.
So we're often approached and asked questions by landlords and tenants around problems that they have. Now, when I started out on this crazy road they call law, basically, lawyers were much more involved with the letting process. We were drafting the assured children tenancy, we were preparing the notices, we were dealing much more with landlords. But as time has gone on, the cost of using lawyers has become a little bit more prohibitive. And so things have developed more along the lines of letting agents carrying out a lot of what used to be traditional solicitors' work. So they will find the tenants, they'll market the property, they'll put in place the assured short-hold tenancy, and often if things start to go wrong, they'll deal with the relevant notices and advise the landlord accordingly. But when we get to the sharper end, breaches, possession proceedings, and so on, generally we find that the landlords will come to us, or the tenants will come to us. And so we thought it would be helpful to set out some pitfalls that we frequently see and which can be avoided. And we thought a webinar would be the most helpful place to do that, so that we can put it somewhere where you can, as a landlord, keep reviewing it as and when you need to. So today will basically be a brief introduction, a brief overview for first-time landlords. It'll give the basics and not a lot more than the basics, but at least that flavour of things should enable you to either research or ask questions or come back to us as you think is appropriate. Now, I wouldn't be a lawyer if I didn't start with a disclaimer. We obviously can't cover everything in this talk. And also the law will change. There'll be case law changes and statutory changes via Parliament. So this is effectively accurate, or as accurate as we can make it as of today, 2nd of May 2020. There will always be unusual situations. There will always be short tenancy agreements that might have an old clause that's no longer used or something. So we try and cover what we call the standard points, but any issues, please get in touch with us. So taking that one step further, the example we're going to be working from primarily today, the restricted example, is a first-time tenancy entered into relatively recently in 2024. The landlord will be a private landlord, so not a multi-occupancy HMO or a social housing landlord. It'll just be a private let. It'll deal with a let in England because the rules are different in Wales and Scotland and Northern Ireland. The terms that we'll talk about and the examples that we'll refer to will primarily be around a short-hold tenancy with standard terms. Now, I put a question mark here because, in my experience, you can deal with 3 or 4 different short-hold tenancies from 3 or 4 different letting agents or landlords, and each will be different, but generally they will have common denominators like rent, breaches, keeping the property in good condition, etc. So what we're really saying here is we're dealing with a bog standard AST, a short-hold tenancy. We're dealing with a single tenant. Obviously, you can have multiple tenants, couples, divorces come into that, or couples that have been divorced have their own separate families and then come together as a new family. We're going to try and strip all that out to keep things simple. So it's a single tenant, and the example of the breach that we're going to be referring to will be for unpaid rent. And then finally, I'll stop in a second, we're dealing with claims in the county court, which is the most common court for things like possession claims and unpaid rent claims. We're trying to keep it as simple as possible so we can enter through.
Thanks, Graham. So the topics that we're going to be covering today in this talk are going to include tenancy agreements, the basics. We're then going to move on to talking about notices. So this is more around termination of the tenancies, where we'll talk about Section 8 notices and Section 21 notices. We'll then deal with possession proceedings. So this is if your tenant doesn't leave on the expiration of the notice. And enforcement. So again, if possession proceedings have been completed, but your tenant has still not vacated the property, then we'll just be talking about those next steps that you have to take. So moving into assured short-hold tenancy. The short-hold tenancy is one of the most common types of rental agreement in residential housing. It is called a short-hold tenancy, but it's often abbreviated to an AST, and an AST may be something you're a bit more familiar with. An AST essentially does what it says on the tin. So it's designed to provide a short-term rental. Usually you will see an AST being granted on a term of, say, 6 months. If it's not terminated or otherwise renewed on the term, expiry of the term, then it will automatically convert into a periodic tenancy. So you can have either a statutory periodic tenancy or a contractual periodic tenancy. If your AST doesn't make any provision for what happens at the expiry of the term, then it will be a periodic tenancy which is governed by statute. Now, your AST may set out exactly what happens at the expiry of the term, and it may, for example, say something like it will roll on a monthly basis. This will be an example of a contractual periodic tenancy. Now, I've listed on the slides what an AST should include. As Graham said, a lot of letting agents will deal with an AST for you, and they'll have their own precedents which you can utilise, which should include most of these standard points. It is just important that you do understand the terms that you are letting on and who you are letting to. So do just take some time to make sure that you are happy with your AST and that it covers everything that you know about the tenant. So, for example, if they've got partners that they're planning to live with them, or they've got pets that they're planning to move in with them in the property. So there are also some things as a landlord that you just need to ensure you've got covered, and ideally so before the tenant moves in. Graham's going to just discuss this with you a bit further.
So yes, we've talked about the actual paperwork for the lease, but there are other requirements that need to be put in place at the same time. We're calling these the essentials. Now, I'm also going to you'll see from the slide, I've asterisked certain points, and this is because, as I'll come on to, when we get to possession proceedings, we may need to be able to demonstrate to the court, if we're going under a Section 21 process, that we've complied with these. So in the round, the property is supposed to be and must be properly maintained and free from hazards, and there's certain information to sort of prove this that you need to give to the tenant. So the first one is what we used to call the gas safety certificate, or what is now referred to sometimes as the gas safety record. The second point is a how to rent checklist. This is basically a government document that you can download from .gov UK website, which points out certain information, gives the tenant certain information in regard to letting and their rights. There is also the energy performance certificate, i.e. how efficient the property is in terms of its energy saving. And you also have to have in place a tenancy deposit scheme, and you need to give the tenant relevant paperwork around this so that they're aware of it. They're the essential four, and as I'll come on to, the court will need those. But you also have to provide a report on the condition of the electrical installations at the property and evidence that the smoke and carbon monoxide alarms in the property are working. Now, this may be a little simplistic, but I flag it just because if you are a new landlord and you are receiving rental income, that is income, and it is by and large taxable. And so I flag this just because if you have any doubts about tax or your responsibilities in regard to declaring tax, please see your accountant, please factor this in. Now, there will be later on in the talk slides where I've set out useful links that cover many of the essentials that I've just run through there. So as Ellie said earlier, there are broadly two forms of notice that are used to bring in a short-hold tenancy to an end: a Section 8 notice, Section 8 procedure, which I'll come on to talk about later, but I'll hand you over to Ellie to talk about Section 21 notices and the procedure there.
Thanks, Graham. So Section 21 notices are the most common form of notice that we find landlords serve. Section 21 is governed by Section 21 of the Housing Act 1988, and it is a wide form of notice. It essentially just says, I'm your landlord, I would like my property back, and you have until X date to leave the property. Now, there's a lot of controversy around Section 21 notices, and you may have heard them being referred to as no-fault eviction. Graham will be discussing a little bit later the government plans around Section 21 notices, but at the time of this webinar, Section 21 notices are still available and they're still being used, so we will continue to discuss them. Now, a landlord will tend to use a Section 21 notice where possession of the property is their priority. Unlike other forms of notice, you do not need to justify the reasons that you want to reclaim possession of the property. For example, you don't need to demonstrate that the tenant has breached the tenancy agreement. You just need to be able to show that you've complied with your obligations as a landlord and that you have served the valid notice. Now, typically, you need to give your tenants at least 2 months' notice. This may differ slightly if, for example, you have a contractual periodic tenancy which renews, for example, every quarter and it isn't the standard monthly roll. Then you would need to give a quarter's notice. But in the vast majority of cases, it's a minimum of 2 months' notice. Now, just to say that the termination date that you elect to use in your notice cannot be within the fixed term tenancy. So, for example, if your tenancy ends on the 25th of June, then you cannot terminate the tenancy any earlier than that. You can't elect a date of the 24th of June, for example. If you do, it's likely that your notice is going to be invalid. So that date has to be after the end of the fixed term tenancy. Now, the notice itself is in a standard form, which can be found on the gov.uk website. It's called 6A, so you'll be able to download that. The key considerations when you're drafting the notice is making sure that you're addressing it correctly to all the persons and people that are subject to the tenancy. So if you're letting to a couple, then that you need both names on that notice. You also need to just make sure that you're stating the correct addresses. And this may sound a little bit silly, but just continue double check the postcode and everything like that. Make sure that that address is correct. It only takes, a slight error for a notice to be sent to the wrong place, or for that to be invalid. So do just take the time with that. The other consideration is just making sure that when you're electing your termination date, yes, it's 2 months' notice, but you need to factor in the deemed time for service. So if you're serving on a Monday, you need to give yourself a couple of days to allow that service to be effected and actually reach the tenant. It's only then, once it's reached the tenant, that 2 months' notice starts. So just to cover yourself, you're probably better to allow yourself a week plus for 2 months. It's better to do that than to realise later that you haven't given enough time and that the notice is invalid. So when it does come to serving and drafting notices, it is important that it is carried out correctly. It is your risk to having to repeat the process can be quite costly. So we're on hand to assist if you need, or your letting agent, if you have one, will probably be able to offer to help you with this. Now, there is just a quick note. I'm not going to spend too much time discussing it in this webinar, but there are a couple of complications with the Section 21 notice if you fall into one of these categories listed on the slides. So starting with retaliatory and revenge eviction. If the tenant has raised concerns in the past or present about the condition of the property, or they've requested repairs which haven't been carried out, then serving a notice to evict them may appear to be retaliatory, and the tenant may successfully challenge the eviction. Now, the legal position is, of course, a bit more complicated than that. And we would suggest that if you are in a scenario where the tenant is complaining of poor conditions, whether with or without merit, then you do just speak to us before you serve any form of eviction notice. Another area of challenge is housing association tenants. A landlord who is a private registered provider of social housing must give certain assured short hold tenants a notice of non-renewal before serving a Section 21 notice. So if you think that that is you, or you think that it might be you, then please just do check and reach out to us to help if you're unsure. Now, moving on to Section 8 notices.
Right, thank you, Ellie. So Section 8 notices, Ellie's dealt with Section 21 and no fault, as it were, evictions. Section 8 tends to be used primarily where there have been breaches or there has been wrongdoing. First, Section 8 of the Housing Act 1988, and broadly under that section there are 17 grounds divided into some grounds that are mandatory, meaning that the judge has to make the order if the criteria are met, and some discretionary grounds, which means that the judge has a little bit of leeway to make an order that may or may not be precisely what you want, or may not have to go ahead. Now, the notice periods, i.e. the period that the notice from being served, as it were, to you being able to take court action, varies under Section 8 depending on which ground you're going on. It's not as straightforward as Section 21 being 2 months. So broadly, it can be immediately if one of the grounds is serious. It could be 2 weeks, which is the scenario in terms of unpaid rent, or it could be slightly longer, 1 month, or 2 months is the longest. So again, please make sure if you're serving a Section 8 notice that you're aware of how long you've got to give the tenant. Now, a Section 8 notice, once it's served, remains alive extant for 12 months. So you've got 12 months to bring proceedings. But normally this isn't a problem, because if you're dealing with a breach or some wrongdoing, you really want to get on with things. As Ellie says, again, Section 8 is a relatively standard form which can be downloaded from the internet from many sources. So again, relatively straightforward. Now, going back to my restricted example, I'm not going to deal with all 17 grounds because that's probably a talk in itself. But dealing with unpaid rent, which is our example, unpaid rent as a mandatory ground is dealt with under ground 8. And what that effectively says is that if you have a tenancy where you are paid weekly, you can apply under ground 8 if you have 8 weeks rent arrears. Similarly, if you're paid monthly, you need 2 months arrears. And if you're paid annually, 3 months arrears. Obviously, most ASTs now, so rent is paid monthly, and so 2 months is the most common. And just to say, the period that you have to give the tenant that I alluded to earlier is 2 weeks notice if you're relying on ground 8. Now, you would normally combine the mandatory ground with any discretionary grounds which are complementary. So for unpaid rent, again, you have ground 10, that the rent remains unpaid when the Section 8 notice is served, right the way through until the date of the hearing. And you also have ground 11, which is the tenant persistently delayed paying rent. And again, both of these grounds have a 2-week notice period. So you'll see the mandatory and the discretionary can be put in one Section 8 notice, and the notice periods all tie in neatly together. Just to talk a little bit around Section 8. Now, I've mentioned the 17 grounds, and I've given examples of mandatory and discretionary in relation to rent. The same applies to all of them. Some apply to deterioration of the property. Some relate to illegal use of. So you need to make sure that if you're going to rely on one of the grounds, that you do meet its terms, as it were. Now, the problem with Section 8 is that the mandatory grounds are relatively straightforward. There's unpaid rent or there isn't. But some of them discretionary grounds are slightly, as per unpaid rent that I've set out, are slightly, looser. So if, for example, you're relying on rent being outstanding between the Section 8 notice being served and the hearing, the tenant might pay the rent the day before the hearing or a month before the hearing, in which case, it leaves you perhaps in no man's land. And it gives the tenant, on more complicated cases involving more involved grounds, for example, has the property deteriorated or not, a little bit more wiggle room in regard to the dispute. So often, as a landlord, you will find that you serve a Section 8, and the tenant might be suitably chastised and might, as it were, take steps to put things right in the hope that the matter doesn't go all the way to court. Now, that can potentially still be a win, but it may mean that you are looking at entering into more negotiation and then not going through with any court proceedings. But it may also lead, and I'll come on to this later, to a scenario where even though you know the tenant is, as it were, guilty as charged, that they're still going to enter a defence to the proceedings, which may slightly change how the proceedings roll, but I'll touch on that later on. So really, as a result of Section 8 being more, as it were, complicated, Section 21 then becomes more attractive, a no-fault eviction. However, there is a bill going through Parliament at the moment called the Renters' Rights Bill. Now, this bill has been talked about for many years. In fact, the last talk that I gave to the local branch of the Royal Institution of Chartered Surveyors was actually on the Renters' Rights Bill just before we broke for COVID. So it's been, as it were, talked about and going through for some considerable time. But at the moment, the bill's had its first reading and it's now at the committee stage in the House of Commons. So what does the bill mean and what does it do? Well, broadly, much of the letting, as it were, much of the letting laws, letting rules came in the 80s, and they said the Housing Act 1988. And so in those times, lets were quite short, 6 months, a year. It was more a transitory thing, with the dream being to buy and own property. But now surveys are showing that the average period that a tenant rents is about 3 years, and that many tenants are renting for 10 or even longer. And going back to the no-fault eviction, the 2 months notice, it was felt that if you are a long-standing tenant and you've been renting for 10 years and your children are at school in the local school, and so you fall within that catchment, it seemed wrong to only give the tenant 2 months notice. Surely they should have a little bit more protection. So what the Renters' Rights Bill, as currently drawn, plans to do is basically do away with Section 21 notices and the no-fault eviction, and put in place, as it were, the equivalent of a beefed up Section 8 notice or its equivalent. So it will still, as it were, there'll still be grounds, and there'll probably be perhaps an easier or more straightforward way to get possession. But the point is the no-fault ground will be gone. So I think, being practical, watch this space. You can download a copy of the Act, and there's lots of articles, a copy of the bill, and there's lots of articles on the bill, but watch this space. But I think the only lesson, the only point to bear in mind is, if you currently do have a problem tenant, you might want to take steps to terminate the tenancy before the bill comes in, because then things may get a little bit more complicated.
Thanks, Graham. So I mentioned earlier that you need to make sure that your termination date in your notice gives you enough time to serve the notice. Now, service of the notices can be done in different ways. There's no specific method provided for in statute. However, proving service is important for a landlord, because if the tenant denies ever receiving the notice, then it is going to be on the landlord to prove that it was served. Now, your tenancy agreement might explicitly provide for effective methods of service. For example, it is becoming more common now to provide for service by email, so it is just worth checking this. But if your tenancy agreement is silent, then we would recommend falling back on the traditional methods of service outlined under Section 196 of the Law on Property Act. So this includes things like registered post, recorded delivery, and personal service. We usually advise our clients to serve by first-class post and by recorded delivery as a minimum. If you have trust issues with the postal system, as I know some of us do, then providing proximity isn't an issue. Then literally videoing yourself, placing the notice through the letterbox is also an option. As silly as it sounds, actually, we would recommend either taking a video of yourself or a time-stamped photo, or just bringing a witness with you If you don't get a receipt when you're doing it yourself, so it really can create a my word versus their word. So the more evidence that you have, there isn't enough that you can do to kind of cover yourself on that. But once the notice has been served, then it is essentially just a case of waiting for that termination date to pass and for the tenant to vacate. Now, unfortunately, not all tenants will vacate on the termination date of the notice, and if they do not leave, you cannot use force to evict them. So this is where we turn to possession proceedings.
Right, thanks, Ellie. So there are broadly two forms of possession proceedings: standard, as I call it, and accelerated. I'll have a canter through standard now, and Ellie will come on to go through accelerated shortly. But broadly, possession proceedings are dealt with under Part 55 of the Civil Procedure Rules, which are the rules that govern court process. To begin possession proceedings, you'll need a claim form, which is in a particular format, which is an N5 claim form. And this is the claim form that deals really with land issues. So it'll deal with unpaid rent, it'll deal with possession proceedings. And there are also a number of other tick boxes on there, but obviously you only need to deal with what you're actually applying for. So again, going back to my example, unpaid rent and possession here. Now the accompanying particulars of claim, which again is another standard document, is an N121, and that's again downloadable from the internet and .gov.uk. But broadly, it's a standard form with fields that need to be filled in, which deal with the rent arrears and the procedures such as service of notices, etc. It's all very much set out for you to complete as appropriate. So hopefully that's the easy part. You'll then need to accompany those documents with a witness statement. Now, in my view, and I've said a few witness statements, the best way forward is to keep it incredibly short and incredibly clear. Deal with the basics. So set out, I think to be at the beginning, set out really a copy of what details of when the assured your tenancy was entered into, and refer to any terms within it, such as the rent, when it's to be paid. Then coming on from that, deal with service of the notice, and as Ellie said, if how it was served, if it was served by letter, if it was served by recorded delivery, include and deal with any evidence around that in the statement. Then come on really to deal in detail with the issue. So if they haven't paid rent, explain that that's the key issue, explain they're in breach of the term in the lease, and explain that that meets the ground. So we talked about ground 8, and that it hasn't, as it were, rent hasn't been paid for 2 months. And again, then go on to talk about the discretionary grounds, such as persistent non-payment and it being outstanding. Often, going back to the example of unpaid rent, it's useful to actually exhibit to the statement or put in it a schedule showing when the rent's been paid and when it hasn't been paid. And in a similar vein, it's often good to actually exhibit to the witness statements the documents that you refer to. So it's now shown to me a bundle of documents marked, in my case, Mead GM1, which I refer to throughout this statement, and then you effectively staple that to the statement and go through. So that's the paperwork. You'll then need an issue fee. You need to pay the court to issue the proceedings. I'm not going to go into what they are here because, as I've said, webinars do tend to date, but if you Google search EX50, that is the court document that sets out all of the court fees, and you'll be able to find the fee for possession proceedings and for unpaid rent. Now, just to mention here, although you'll only write one check, as it were, or have one fee to pay, if you're claiming rent arrears and possession, you effectively have to pay a fee for the possession and a fee for the rent arrears. And the rent arrear fee depends on how much rent you're paying, all set out in the X50. And I'm not going to go through it all because we're here all day. But just to bear that in mind, it's almost like a twofold fee. Now, broadly, you can either send those to the court under cover of a letter and ask for the proceedings to be issued and served on the tenant, or you can take those proceedings to the court yourself and get them issued. And normally for possession proceedings, the court that you're looking for is the local court for the property. So again, take a look at that before you sort of saunter off to a court that's further away. Now, I've said here, you have a choice in terms of how many copies you provide. Now, broadly, you'll need a copy per tenant. My example deals with one tenant, and so I'm dealing with a lesser amount. But as Ellie's touched on, if you've got multiple tenants, it will be one per tenant. So, taking my restricted example, one tenant, you have a choice. If you want a copy of the proceedings to come back to you, you would send 3 copies or give 3 copies to the court, one for you, one for the court file, and one to be served on the tenant. But you can forego the copy that comes back to you and just basically send in or turn up with 2. But I always ask for 3 copies because I like a full copy of what's been issued and what's been served on my file. Now, once the court has processed things and issued proceedings, you should receive 2 pieces of paper, and obviously a copy of the proceedings. You've asked for that, but 2 pieces of paper. One is a notice of issue, which says the proceedings were issued on that date, and that's effectively just good for you to keep for your records, so you know that you've got it and it's happened. And the other is the hearing date. Now, you used to be able to almost work out you get the hearing date in 3 months from the date that the proceedings were issued. Unfortunately, since COVID and with all the cuts and the pressure on civil servants, this can really be anything from 3 months to 6 months or even longer. So I'm not going to hasten to make a guess, but just to say you'll get back 2, and the tenant will be served with a copy of the notice of hearing also. So you have what we call a return date, which is where your application and when your application will be dealt with before a judge. So I touched on, you've issued your proceedings, they've been served on the tenant, you've got a date in the future, what might happen next. Basically, as I outlined, the tenant, if he's not happy with the grounds that you're claiming under, say, for Section 8, this would generally only really apply to Section 8, because Section 21 is a no-fault ground. As long as you can prove that you've served them properly, there shouldn't be a problem. But obviously, if you haven't served them properly, they may defend on that basis alone. But broadly, if the tenant is not happy with anything in regard to the notices or the particulars that have been served, they can defend. Now, that may take the form of them going to see a solicitor and drafting a document which is really the responding document to your claim form, which is a defence. And in that, they may say, for example, I have paid the rent, or I paid to this account rather than to another account that you've used. And again, that may be something which is valid. It may be, if it's to do with one of the other grounds, for example, illegality of the property, you've accused them of using it as a drug den. They may say, we haven't been using it as a drug den. So you may get the document through, which is a defence, or the tenant may turn up at the hearing and raise these defences. If the judge sort of takes that defence seriously, what he could or she could do is put in place a timetable of what we call directions. So effectively, they timetable a series of stepped events that need to take place before another hearing or before the trial itself. So going back to, as it were, they claim that they've paid. It may be that the landlord will say, I'd like you to disclose, as I put here, disclose documents which prove that you've paid that by way of, for example, bank statements. If we're dealing with, for example, deterioration of the property, he may say, I'd like a surveyor's report from each of you, or a joint surveyor's report, one from both of you, which effectively states what condition the property is in, and that the claim, that is made is valid. It may be that there's an allegation around service of the document, in which case we say, oh, well, I took my friend Ellie along with me. So he may say, well, I'd like you to get a witness statement from Ellie and put that in. So this will be a timetable through to trial. And it may even deal with, for example, trial preparation, who prepares the bundle, when it's to be filed, etc., etc. So I flag this just because I'm going to come on to what normally happens at the hearing. But if a defence is filed, it may slightly change the trajectory that you are on. So, trial considerations. Now, this talk is aimed primarily at landlords. And so landlords are primarily going to be the claimants in this situation. The claimants have certain common responsibilities, one of which is to prepare the bundle for the hearing. And normally, as a rule of thumb, it's good practice to get that bundle out and to the tenant or to the defendant, as they now are, in good time. I would say 2 weeks before would be good. But again, you may have a directions timetable or something from the court which specifies precisely when. What should be in that bundle? Well, really, everything we've touched on. A copy of the assured short-hold tenancy would be good. A copy of the notice that you've served, yes. A copy of any evidence around proof of service of the notice as well should be in. Pleadings, being the claim form, particulars of claim, witness statement, defence, and any witness evidence to the defence should go in. And if there has been a timetable in regard to a defence, probably better to put each of the steps in, so the bank statements proving payment or not, the extra witness statement and the surveyor's report, all of that should go in. And ideally, taking my example of unpaid rent as being the theme through this, an updated rent schedule should also go in. Now, I touched on earlier that Section 21, the Section 21 process requires more in regard to evidencing that the basics, the essentials of the let have been complied with, and I touched on that should be the energy performance certificate, the tenancy deposit certificate, the checklist, and the gas record, the gas certificate. So again, if there's any arguments or issues around that, and really generally, it's quite good practice to put those in, because the judge will actually turn around sometimes and go, have you got an up-to-date copy of the gas record? And it's useful to have that. And finally, I think anything else that's relevant, if you've served a notice and you've had a horrible letter back or email back from the tenant saying, I'm not paying, go and take a long run off a short pier, then put that in, because it sets the scene. The judge will look at it, and while on the day he's probably got a very chastised tenant who is, very, considerate and is dressed very well and trying to give the best account of himself. If there have been horrible emails, that will obviously show the tenant in their true light. So that's broadly, I think, what puts in the bundle. But if in doubt, put it in. But it is a balancing act, because if you put in too much, the judge won't read it, and it may also render the bundle to a certain extent irrelevant. Now, probably for possession proceedings, you would have consulted us or another solicitor to take things further forward. But if you haven't, I just touch on a certain form called an N260, which again is downloadable. You can find it on the internet. And basically, this is the form that must be filed if you want to claim your fees and your lawyer's fees. Now, the lawyer will complete this if you have one. But if, for example, under the terms of the short-hold tenancy, you're entitled to claim your fees for doing it, as it were, your time, please ensure that you look at this. But I'm not going to go into any more detail, because, again, completing forms, it's another webinar, really. So that's the trial bundle. Now, the trial hearing. Now, when I speak to clients, there's always a lot of fear around the hearing. And I think a lot of us have watched TV programs, Kavanaugh, QC, etc. And we see it as men in wigs with a sash, and it's all very formal. Just to reassure you, possession proceedings are not going to, shouldn't be like that. Normally it's a room, unlike this one, large rectangular desk in the middle, judge at the narrow end. You as the claimant sit one side, defendant, the tenant, sits the other side. Judge is in a suit, there's no wig or performance, it's just very much a room. You'll come in, the judge will say, sit there please. And then, it's effectively more like a meeting. So what should you do? Introduce yourself. Hello, I'm Graham Mead, I'm the claimant here, and I'm the landlord of the property. Introduce the tenant. My opponent today is the tenant, Mr. Smith or Miss Claffey. If they turn up, again, in my experience, 9 times out of 10, the tenant will know they're in the wrong. They'll know they're on hiding to nothing. And so if it's to do, especially with unpaid rent, they may not turn up. If it's slightly more complicated than that, like illegality or similar, you may find that they do. But anyway, it's a bit of a lottery. Explain to the judge just simply that this is an application for possession proceedings, and explain what you seek. So go into a little more detail. You want a possession order, you'd like unpaid rent if that is what you're seeking, and also you'd like your costs, but only just touch on those. Don't go into detail. I'll come on to more of that later. It's always good practice, just as courtesy, to ask the judge, who you can refer to as judge, or sir or ma'am. Ask the judge if they've read the papers or whether they'd like you to summarise. Often, if it's two lay people, the judge will take control and say, no, that's fine, Mr. Mead. I will take control of this. Sometimes they'll say, no, thank you, that will be helpful. Tell me the story. In which case, without stating the obvious, really take the judge for the salient points. And I would advise that you stick to the basic, as it were, skeleton argument that you've set out in your witness statement. I entered into an assured joint tenancy with Miss Claffey on such and such a date. Under the terms of the tenancy, rent is to be paid at X per month. Rent hasn't been, and on the first of each month, rent hasn't been paid X per month, and therefore she's in breach of the tenancy. I therefore like a possession order. I therefore like rent arrears, and I'd like my costs. And really highlight as you go through, as I've said, the breaches. So, for example, that there is the unpaid rent, and that it's an issue. And again, as Ellie's touched on, good practice to highlight proper service of the notice, just because these will be things the judge will be looking at. Now, as I said, normally you don't deal with costs at inception, touch on it as I've said, but don't actually address them. And normally the judge will come back to them. So you've reached the point where you've gone through the salient bits. The judge, what happens then? Well, the judge may ask you some questions, or he may take control and ask the tenant questions. He may say to the tenant, just simply, tell me your side of the story, in which case the tenant will roll off their side of the story. He may, in the sort of more traditional evidence in chief, cross-examination, re-examination, he may give the tenant the opportunity to ask questions of you and you to ask questions of the tenant. Would you like to ask the landlord any questions? Would you like to ask the tenant any questions? And if you have questions, then, I would ask them, a good one with unpaid rent is, do you accept that you haven't paid rent? In which case, if they say yes, then obviously half your job is done. Now, the judge may also say, after he's heard from both parties, and he's made their £2, given their £2, are there any further submissions you'd like to make? In other words, is there anything else you'd like to say? And again, if you do have something, please say it. But if you feel you've addressed everything, my view would be leave it there. Don't labour it. Judges get it. This is a relatively, if it is an unpaid rent, for example, it's a relatively straightforward, path. So keep him with the judge, and she has got a list of these probably all morning and all afternoon. So help them to help you and keep it short. Now, if you're successful, he should give judgment. And then once he's given judgment on the possession and the rent, they will usually say, is there anything else you would like to address me on? And that is the point where you deal with costs in earnest. And, if they don't ask you, then I think that's the point for you to then put your hand up and say, Judge, you haven't dealt with costs, if in fact you are seeking them. So again, on costs, address the judge on costs, and I think keep it short in terms of the basis. The tenant's in breach, you found for me, so I wouldn't use the phrase I found, but broadly you found for me, and therefore it follows that I'm allowed my costs, which is a sort of precedent under English law. So it may be, as I've outlined before, that under the AST, you're actually entitled to your costs. So if you are, again, flag that, because that will make it even easier. But just explain, therefore, what your costs are, how they've been incurred, that you think you're entitled to them. And if you put in a Form N260, as you should, the judge will then review that and deal with them. If you haven't put in N260, you can still address the judge on costs, and he'll then sum up. Now, he'll make an award on costs, hopefully in your favour. He may not. I make no award as to costs, and he'll wrap things up. Normally what he'll do, and this is sort of in the round, he'll order possession. That's normally 28 days. I've said here it can be shorter, but it can also be a little longer as well. But he'll make the possession order. If there's unpaid rent, that's normally payable within 14 days. And if there's costs, again, that's normally payable within a period that is set out, normally 14 days. But again, it's in the discretion of the judge. So that's the trial hearing.
Perfect. Thank you, Graham. So Graham has given us a good run through of the standard possession proceedings, and as you can see, they can be really quite long and drawn out. So for simpler cases where you are seeking possession off the back of a Section 21 notice, you may be able to use what we call the accelerated possession route. Now, this route is usually quicker, and it is usually completed on paper, meaning that there is no hearing. Now, the accelerated procedure isn't open to all cases, and I've listed the criteria on the slide for you to review at your own convenience. The main one being that it can not be used if you are also looking for an order for payment of rent arrears. So some clients decide that they will separate the claim for possession from their claim for rent arrears, so that they can utilise the accelerated possession procedure, and they can then just sue separately for the rent arrears in the small claims court. Now, the accelerated possession claim form looks quite different to the standard claim form, which Graham was referring to. Unlike, you haven't got the witness statement, the particulars of claim, for the accelerated possession claim form, it's more of a tick box exercise, which is another reason why it's also preferred. You'll have to be able to attach your evidence. So you have to be able to attach evidence that you've complied with all of your requirements. That will be things like your how to rent guide serve, the gas safety certificates, and things like that will all need to be annexed to your claim form. And the form itself will guide you through that and how you need to annex them. You'll also have to be able to provide that the dates that you have served the documents on your tenants. So your gas safety certificate, for example, that will be a yearly thing. So if you've had your tenant in there for 5 years, your gas safety certificate from 2023, what day you served that on your tenant. So it is useful if you have all of that information. There's a court fee payable at the time of filing the application. So at the time of recording this webinar, the court fee is £404 in the county court. It's slightly higher in the High Court, but most cases you'll be issuing in the county court. The fee does change regularly, so please just consult the EX50 document which Graham referred to. It can be found on the Gov.uk website. It is rather self-explanatory, but yeah, just give it a good read. So once you've filed your claim form with the court will issue it and they'll serve it on your tenant. Once the tenant has been served, they have 14 days to respond. So they'll either defend the claim, perhaps by claiming retaliatory eviction, like we discussed earlier, or they will ask the court for some more time. They may, for example, plead that they are searching for alternative accommodation, or that they're just waiting for somewhere to become available. If the tenant does respond, their response will be sent to a judge. The judge will do one of three things. So they will either make an order for possession without a hearing. So they may do this, for example, if they don't think that the defence has any merit. They might fix a date for a hearing, and the process at that point then essentially will be transferred to the standard possession route. So you're sort of back on track with what Graham was discussing earlier, and then you may have directions and witness statements, etc., to follow. And that's kind of used more in circumstances where the judge might think actually they might have a point. Maybe there is a bit of revenge eviction going on here, and I need to hear it out properly. And alternatively, if the judge reviews the defence and revisits your application, then they might decide to strike your claim out entirely. Now, this is more likely to be in cases, for example, where the tenant has pleaded that they haven't been given the necessary notice period, and the judge actually looks back and says, "Oh, actually, you should have given 2 months. You've clearly only given them a week. It shouldn't have been issued, and you can't use this. You're going to have to start it again." Moving. So, if a judge does grant a possession order, and the standard time given to the tenant to give up possession is 14 days from the date of the order. Now, as I touched on, an alternative to pleading a defence, a tenant might plead for more time. Now, as part of the accelerated possession application form, you will be asked a question. I've actually highlighted this question on the slides. So it says, if the defendant seeks postponement of possession for up to 6 weeks on the grounds of exceptional hardship, is the claimant content that the request be considered without a hearing? So that's asked right from the outset on your application form. Now, most landlords will tick yes and say, yes, that's fine. I'd rather save the hassle of a hearing. If you tick no, then what's likely to happen is the judge is likely to grant the possession order, but they'll list a hardship hearing, decide if the tenant should be given more time and that vacation date should be set back. Now, in either case, a judge has a limited power to grant more time. So they can only give the tenant 6 weeks, and this is a hard and fast rule. So in most cases, because of this, a landlord will just say, yes, it's fine. It's usually easier to just give them a few extra weeks than argue the point. So now by this stage, you've served your notice, you followed the possession procedure, whichever route you've taken. You've obtained that possession order confirming the date that your tenant must vacate the property. So what happens if your tenant still doesn't leave? Now.
Right, thank you, Ellie. So yes, you've done everything right, and the tenant's still there. The possession order was made. It's been given 28. She's been given 28 days to leave, but they don't. What do you do? So broadly, we're then into what we as lawyers call enforcement, and what is commonly called for possession claims, eviction. So basically, again, I'm going to focus on possession here, but in the county court, you use bailiffs. In the High Court, you use High Court enforcement officers, or what have traditionally been called sheriff's men. You need to fill out a form for what's called a warrant for possession. And again, these are available from the court or online. And in that, you effectively set out details of the order and what's happened, and effectively that they remain in the property. There's a fee that's payable, again, back to good old form EX50, and then you either post that or take that to the court and ask for an eviction. What happens then? Well, the next 2 points are really they can happen in either order. In my experience, the bailiff will often phone you and ask you a number of questions about the eviction. Now, those questions are primarily going to be more around how difficult the eviction would be. So, is the tenant violent? Does he have a big dog? Are you on the 8th floor or the ground floor? That type of thing. And that's really just so that he knows what he's dealing with and how many bailiffs he needs with him. But it can happen the other way, which is, again, the more traditional way, whereby you are sent, much like it would be the court proceedings that we talked about, an eviction notice, or details of the eviction notice, and that will effectively just be a date and a time. And the court will send you that sometimes, and the bailiff will phone you shortly before the eviction. As I say, they're pretty much interchangeable. So what do you need to do? You've got your date, your eviction date, what do you need to do? Well, in that scenario, you effectively need to arrange a locksmith and just turn up at that time with the locksmith and wait for the bailiff, and ideally sort of park quite near or loiter around so that the bailiff can actually see you and you can identify yourselves. And again, no doubt you've probably been in touch with the bailiff in any event. Usually, and I flag this just as a side issue, usually in my experience, 9 times out of 10, the tenant will have already left and the eviction runs through smoothly. And the reason that normally happens is because local government will only provide emergency housing in worst case scenarios when they know that an eviction date is taking place. So in a way, you often have to get to this point to effectively then, as it were, have a scenario where the tenant is provided with alternative accommodation to leave. So because of that, normally the tenant's already gone, and you're often left with sort of like an empty property. It might be need a clean or whatever, but it's generally sort of unoccupied. But sometimes, and this again is the exception to the rule, the tenant may still be there, or more relevant. The tenant may have actually left things, their possessions in the property. So what happens then? Well, normally the bailiff will take control, we'll have a discussion with the tenant, and the eviction will still go ahead. But they'll deal with, as it were, the tenant per se. But if it's just items that are in the property, the bailiff will still probably, or may probably still contact the tenant to let them know. But often there is no forwarding address or whatever. But if you have one, I think you've got to deal with the tenant, the former tenant, and basically say, I'd like to move your items out. Can we agree a day when they can go? If you don't have a forwarding address and you don't, they're not playing ball, then there is an act called the Tort Interference with Goods Act, which deals with this situation where effectively items that don't belong to you are left on your property. And I'm not going to go into detail here because it's probably another seminar on its own. But you've got two choices really, or even you can combine both. But you normally have to exhibit a notice or send a notice to the tenant, effectively saying that you will dispose of the items and giving a reasonable period of time for the items to basically be removed. And if those items are valuable, again, usually they're not, but if they are, then there is actually a court process that you can choose to go through, where you get a court order effectively indemnifying you, giving you sort of an order that you can stand behind to get rid of the property or to keep it, or directions to what to do with it. So again, 9 times out of 10 it's fine. If it's not, it's Tort Interference with Goods Act, and probably, if I'm honest, a discussion with your lawyer. So thank you for being with us today. That was a very quick through, and we tried very much to keep it to the hour. A letting agent, and as I said, a modern way of dealing with this is a letting agent will probably give you a lot of this information, so you don't have to worry about it. But if you have any doubts at all, please do not hesitate to get in touch. Now, I said earlier in the webinar that we would set out useful links, and the slides to this talk will be downloadable, so there's no great hurry. But just to quickly run through how to rent checklist, there's a link. I've given you details of the National Residential Landlords Association. That's a useful website, but again, you may have to join. Details around what you need for gas and gas register are there. Details around electricity from that Health and Safety Executive are there. Energy Performance Certificate, a link. Tenancy deposit schemes, a link. And smoke and carbon monoxide requirements, again, another link. I've even put down tax there. How to let guides, which is more a general guide. We've got .gov.uk, and also shelter, just in case. There's useful stuff on there for landlords too, but just in case there's a tenant watching, we've got a fallback. So, if in doubt on anything, please do not hesitate to get in touch with us. And our contact details are there, including our LinkedIn details. Thank you again. Please get in touch with us if you need. And I hope you found this talk useful.
Thank you, Ellie. Thank you. Thanks very much.